Hi friends, the term to be discussed today in this video is parallel import. This is Bindu Sharma from Origin. Purpose of this series of videos, Key Terms Patent Act, is to understand important terms used in the patent law. Before we understand parallel import, let's understand the term exhaustion of rights. This is the principle whereby the right holder's IP rights in respect of a product are considered to be exhausted when that product has been put on the market by IP holder or a person who is authorized by such IP holder. This means that the patent owner can no longer exercise any rights once the product has been put in the market. In other words, we can say that after a patented product has been sold by the patentee or by others with consent of patentee, the IP right is said to have exhausted, and this IP right cannot be exercised by owner of IP. This principle is also called as exhaustion doctrine or first sale doctrine. To understand how patent rights are exhausted, let's take one example. For example, if an inventor obtains a patent on a new kind of pen, the inventor can legally prohibit other companies or third parties from making and selling this kind of pen, but he cannot prohibit customers who have bought this pen from the patent owner from reselling the pen to third parties. Or we can say the rights of patent holder are exhausted after he sells the product or the pen to the customer. In Indian Patents Act, exhaustion doctrine has been mentioned under section 107A. Certain acts not to be considered as infringement. With respect to patents as IP rights, there are certain exceptional acts where the use of patented invention without consent of a patentee does not constitute infringement. They are also called as exhaustion of patent rights. For example, importation of patented products by any person from a person who is duly authorized under the law to produce and sell or distribute the product shall not be considered as infringement of patent rights. This concept is commonly called as parallel imports, and I will explain it to you more in detail in the further part of this video. According to the concept of parallel import, importation of patented products by any person authorized by the patentee will not be considered as infringement of patent rights. Therefore, it is possible to import the patented product from the licensee of the patentee in any country without the permission of patentee. The purpose of parallel import is to check the abuse of patent rights and to control the price of patented product by taking away the monopolistic power of the patent holder. It's very important to understand that parallel import, also called as grey market import, is not unauthorized, unofficial or illegal sale, nor it is sale of pirated or counterfeited products. Rather, parallel imports are genuine, often branded products that do not violate an IP right, and they are legal in most of the nations. I will explain you parallel import more in detail with help of one illustration. Before that, you must understand rights of patent holder clearly. Well, a patent holder can prevent third parties from making, using, selling, offering for sale and importing the patented item in the territory where there is a patent protection. Suppose a company called Blue Pharma has a patent for a drug in India. This company has licensed its patent to Red Pharma in Russia. Here, Blue Pharma is patentee, while Red Pharma is licensee, and Red Pharma is authorized by the patentee or patent holder to sell the drug. Now, Green Pharma in India buys the drug from Red Pharma and imports to India. Even though Blue Pharma has rights in India and it can prevent Green Pharma from importing the drug in India, principle of exhaustion of patent rights come into picture here. Since Green Pharma is buying and getting drug imported from Red Pharma, where Red Pharma is duly authorized under law to produce and sell or distribute the product, importation of drug by Green Pharma in India shall not be considered as infringement of patent rights. This is what the concept of parallel import is, and I hope this is clear to all of you. If there are any further doubts, you can let me know by leaving message in the chat box below. Now it's time for the question. Question for the day is, according to section 107A, if a patented product is imported by dash, it will not be considered as infringement. Option 1 is patentee. Option B is any person authorized by patentee. Option C is licensee. Option D is defendant. You can put your answers in the comment section below. Thank you for watching this video. For any queries related to our services, you can contact us. Email ID and phone number is given in the video description. See you next week. Till then, keep learning and keep innovating.